A very good afternoon to everyone. Thank you so much for joining our today's session. We would be talking about contract drafting today. As we all know, contract drafting is a very basic but a very essential skill that a lawyer can have. It is somewhere that you can, you start your services. This is kind of like gateway services a lawyer can provide to his clients and start building up his profession. That this is like starting point. At the same time, it is not a very basic thing. It is a very specialized service that you'll have to follow it. With respect to that, we are very honored to be joined by Mr. Gulshan Kumar Sachdev sir. He is an outstanding lawyer. He has an experience of more than 18 plus years. Uh, of these 18 years, for 15 years, he had been working with different reputed organizations like Z Entertainment, Capital First, Aviva Life, ICICI Bank, Oryx, and he has also worked with ASG offices. Currently, he is running his own firm. He's a partner at Sachdev and Associates. The firm has a specialization in handling commercial disputes and criminal issues, and have clients across the industry. They have good clients, big clients. So he has a very good experience, and what could be better than learning from the top advocate, the very skills in drafting of contracts. So I'd be stopping here, and I'd request Gulshan sir to please take the stage, and let's start with today's webinar.
Hi, good evening, friends. Yeah, let's start with the topic. The contract is a very basic document for any business or all that. So drafting is a very key to that, because when you employ someone or you assign any activity, whether it's a services, production or all that, so contract plays a major role. To draft it is a very kind of a method. You have to be very picky. Suppose I am representing a client, I have to ensure that the interest should be ensured. I interest in the future, because you can't anticipate everything, but you can anticipate few things and you can work on few areas. So contract drafting in such a way that your client should be safe enough in case of any eventuality. Because it's like a marriage. If it goes good, nothing is wrong. If goes something wrong, obviously then there is a allegation, counter allegation, then so many things are altered. So you have to be very careful while drafting the contract. First, we start the contract. In what capacity you are bringing contract? It could be a assigner, assignee. It could be a service provider. It could be a production house. It could be a you are giving a some part of a manufacturer. You want to manufacture a big thing, like suppose you are manufacturing a car to manufacture a steering. You will give a contract. So you have to ensure that first in what capacity you are doing, and in what capacity, that and what is the scope of the contract. First, the basic detail of the parties. Suppose the company A, company B. Company A contains its details, registered office, by whom it's given. That is very important. Sometimes we miss who is signing the contract. So always mention the company is represented by this one, because later on the person says he was not authorized to contract. So you have to be very sure the person who is entering into contract, he is holding some authority from the board to enter into a contract, so that the company cannot come and say later on he was not authorized to carry on the contract, he was not authorized to sign the document. So the name of the person and his designation, he could be anyone. You can't ask every time for an MD to sign the agreement. He could be anyone, but he should be well authorized by the board, by the company, to enter into agreement. So company, whether it belongs to includes a subsidiary as well. So parties details must be very specific and clear. As soon as you have the clarity in the contract, you will be very much safe. Now, after the parties, then what is the scope of the agreement? First, let me take the definition of the contract. What does the section 10 of the contract says? Any agreement which is for the consideration, lawful consideration and lawful object. So you cannot make any contract which is of unlawful activity. That should be a valid agreement only for the legal activities. So any illegal activity, that is not enforceable or all that. Okay. Then first we start with the company details. Basically company A, company B. Then the scope of work. Scope of work is very much important. How much the activity, what kind of activity you are assigning to each other, and what is the scope of the work. Suppose somebody is assigned for any production agreement, somebody is assigned for loan agreement. There is a contract for the, like in industry, you could be contract with only for a few. Suppose you are making a movie, you need a only music composer or all that. So that could, there could be there are three types of contract. One is with the artist, one is the music company, second the music composer. So it depends on the scope of work is very much important. Then you have to first, when you start, after scope of work, definition is the key. What kind of definition you will cover? Definition should be very vast. What are the terms you are using in a contract? The definition is very much clear, so that in later on, it should be clarity that definition will be interpreted in this particular way. So suppose I'm just giving an example. You are taking a banking company. Obviously I am part of some bank, so I know. So what kind of definition you have to manage? Who is a lender, mortgage, repayment? All these should be part of this. Suppose this is a music contract. So what is a film? What will that scope of what definition of film? What is the definition of the lyrics? What is the definition of the composer? So definition should be the well-versed. It should be the totally complement to the what is the scope of your contract. Sometimes we know that we don't need to definition. You have to interpret each and every definition very carefully, because suppose there is too many. So many things are there, and it make a mess. So every definition should be very much clear, and it should be interpreted in a very clear way. After definition, then again, what is the terms of the agreement? You are appointing only for a few period. You are appointing for the term is very much important. Then after a term, it will be automated or it will be renewed. That is also sometimes we miss it. The party has right to renew the agreement. No, don't give such right. You should be very clear after this term whether it should be expired or it can be re-entered with a fresh agreement. So don't give this kind of option to the other parties. It may make it some type of mess. Okay, definition and interpretation. I'm again repeating. We can again summarize. First, the parties, detail of the parties who are coming into contract. Company A, company B, company A who is authorized, then details should be very much clear who is signing the agreement, at what capacity he is, that is a similarly company B is signing, so who is signing the agreement, what capacity, so that later there should not be disputed that we have never authorized this person to enter into agreement with someone. Again, then scope of the work. Scope, sometimes scope, if you can interpret scope, if you can define scope in 2-3 lines, well and good. If the scope is vast, so make it as a separate annexure or enclosure. That should be read as a part of a contract only. So scope of work is limited to 3 lines, then it's okay. But you think you have to cover so many things in scope of work, so you make a separate annexure. If it consists of 2-3 pages, make in the end of the contract, you can name it as an annexure 1. This is the scope of work, annexure 2, whatever that is. Okay. Then we are coming to definitions and interpretation. Again, definition very much key. Definition contains these are the definition. There may be 10, 12, 15, 20, and how this definition be interpreted. Okay. And every definition should be as per law. You cannot make your own definition. You cannot definition as per it should be in what defined in a certain act, or it is in a common sense, something prevailed in the act. You cannot make any definition, and similarly it should be interpreted in this way only. Definition and interpretation. Then the terms of the agreement. Terms is very much important. You are making contract for 6 months, 1 year, 2 years, 3 years, 4 years, whatever. After terms is very important, and how after this terms and termination also can be covered here, how the parties can terminate the agreement. Sometimes there are 2-3 in termination, 2 things are very important. One, you are defined after 2-3 years, it is automatically terminated, or they are happening of certain events. Termination. A party fails to do certain works. If it has a party failed to perform a duty, then it requires notice. Sometimes termination is implied, sometimes you have to invoke the termination. So that you have to go in this way only. One thing more, scope of the work is also very much important. Scope, it's a phase-wise. Suppose an activity cannot be done in a one way. So it is a combination of 2-3 activities. You have to cover everything into that. You cannot come, if it's in the part, so scope 1 this, scope 2 this, scope 3 this. That is very much important. Once the scope is over, then termination. Termination also, how the communication will be sent. How you, to who is authorized to send the company, who is authorized to send the termination, and where this termination. Achha, one thing more, whenever you mention you are entering into a contract, you are sitting in anywhere, you have to mention the registered office of the company, because company is known by its registered office. Registered office plus the office situated at this place where the agreement is agreed. And the agreement is, sometimes we miss the date as well. That is also very much key. There are so many agreements where date is kept blank, but date, because you everything shall be counted from the date only. If the date is blank, again the terms will be affected or all that. So parties detail and the date of the agreement, terms, all these are very much keys to that. After that, definition or interpretation, we come, what is the scope of the work? I already defined to you. Okay. Then it comes what the representation and the warranties. Representation and warranties are the key. Suppose a party is representing that they will do this capacity. There is a very little difference between the representation, warranty, and the covenants. All three are interrelated, or all three could be independent as well. First, representation what? Where you suppose if the parties, why representation is important? Because a contract is voidable on the base if there is a misrepresentation. The courts doesn't interfere into any agreement. If there is a valid agreement of parties, the court don't interfere. There's so many judgment to this. So you have to very strict that if there is any misrepresentation, then the contract is voidable. So if there is any kind of a misrepresentation, obviously one party will be in trouble. The other party has option to make it voidable. Voidable means they have option to declare it void. They can go to court because we have been misrepresentation that they will do this, but actually they were not. So some kind of misrepresentation has been done in this company, in this infrastructure. Suppose somebody approached me, they have infrastructure and they can provide this activity, but later I found they don't have infrastructure. So this kind of misrepresentation. So representation is very much key. Ensure that the party who are coming to contract, they represented you every very fair thing, very small thing, which are necessary to carry out the business. Similarly, if you are on the other side, you ensure that whatever you're writing as a representation, it should not be in heavy. It should be very clear. It should be unambiguous. You should not make any representation which you cannot do that, because it gives other party to make it voidable. Second thing, warranties. Warranties also is a part of a representation. What warrants you? What is required to carry out this contract? So representative warranties, these are also one of the part. One thing more than covenants. Covenant says that the person, he can do what he cannot do in a particular contract. That is also very much important. Then we can come, if suppose we are giving somebody appoints some service provider to do service on companies. So what kind of IPR will be there? That only you are only agent. You cannot use my IPR for this thing. So warranty is also a representation. That's also a key area. Sometimes we ignore that, but that should not be ignored. Both the parties. You have to ensure that whatever we're writing, that should be true. That should not be any misrepresentation, any kind of a wrong warranties or any kind of a wrong covenants. Covenant also plays a important role. One is what to do. Second, what not to do. During the contract, the other party will not assign with any competitor. That is one of the things. During the contract, you will provide all this activity exclusive to us. In a contract, obviously, when a company manufactures one thing, they make subcontract for the 10 things. And once they have a monopoly, they would not like the party should engage to other activities as well. So they ensure that if you are manufacturing this for me, it should be exclusively passed to me only, not to any other person, because I have a monopoly. They supply to other, I could lose a monopoly. So that all representations, warranty, and covenants. These are also one of the very important things in a contract. Then again, I told you in a service agreement, suppose somebody is coming, So the IPR part, that you will not use anything without the permission of my company. You will not use any logo. And after that, suppose the product is made, it shall be totally transferred to me, my company. You have no right. So all these points are the parts of the representations, warranties, and covenants. How do you cover it? It depends on the from the one contract to other contract. Okay. Then the next part is if there is a dispute comes within the parties, how will it be taken? Sometimes it's a civil courts. Sometimes we have arbitration. And arbitration plays a very key role, because if once you have accepted to arbitration, then civil courts have no jurisdiction to all these things. You can go to civil court only for the interim relief for all that. But once, if there is arbitration, the parties are governed by the Arbitration Conciliation Act. So the civil court has no jurisdiction to that. You can one party can approach to court, high court, or all that only for the purpose of appointing arbitrator or all that. Again, I am saying one thing: if there is a valid contract with the parties, the courts don't interfere into it. There are so many judgments to this part. Okay, then definition. One thing more, so indemnity. That is also one of the key clause. What does mean indemnity? Indemnity means suppose if any loss occur to me, this I will shall be indemnify the other party. That is the scope for the indemnity bond, indemnity clause. That is also one of the keys. And then the confidentiality. Suppose you are making one particular part or one particular thing for me, that you will not pass this information to others. Today, apart from the contract, generally in case of where there is a, like we all are using technologies or all that, there are so many contracts for technologies. There the concept of NDA also comes. NDA is non-disclosure agreement. Non-disclosure could be part of the same agreement. It could be make a separately agreement, but it has a very wide scope, non-disclosure. From it, non-disclosure agreement means you shall not, the other party shall not disclose anything without my consent, without my knowledge or all that. So it all depends how, for what kind of contract you are doing. Manufacturing, you have to ensure your product, if you have monopoly, you don't want that it should be shared with others. And a service provider, the service should be provided to you. Service provider should not misuse your brand name or all that. In a music kind of a thing, that the IPR, if the IPR function comes into picture, the product or who will hold the IPR rights, obviously the person who is making this, suppose me, I am making a film, I have assigned musician, lyricist, composer, and music industry. So obviously the producer holds the all kind of rights with it. So that things are very much important. The scope of contract, and then to the what kind of contract you are having. So then copyrights is there, the IPR part, IPR. Then you can say assignments or all that. Whether it can be, whether you can sub-assign a contract this activity to other. If you think it won't jeopardize your interest, obviously you will allow other party. If you think it could jeopardize, so we won't allow the other party to make any assignment or all that. Publicity, same thing. So you should be very clear what kind of things you are requiring in a contract. You have to take feedback from the management on these points, things. Then your everything should be compliant with the law. If you are making anything like which is against that you are stopping somebody doing any other activity which is against section 253, then your contract is not valid or all that. So what you do, that it should be within the scope of the law, but you have or every right to protect your own interest. So then we have this thing, I have already discussed arbitration or all that. So any question on this you would like to see from any of the viewer?
Sir, there was a question. So one of the student wanted clarification on the scope of agreements.
Yeah,
what
scope
does,
of
yeah.
Scope of agreement means for what activity you are assigning others. Suppose I am a manufacturing company. I'm making we are a manufacturer of a car. Okay, for car we require 10-12 parts. Okay, I could assign one part to one particular company. So that will be a scope of work. So if you want to have any specific query, just raise what is a confusion to scope of work, for what purpose you are entering into a contract. For what purpose? What is the objective of this contract? That is a scope.
Right, sir.
Is it clear, or you want to? Scope means the purpose of this contract. For what purpose two parties are coming? For what purpose? What the one will do? What will the other will do? The one will assign the contract. The other part will pay. This is the scope of the work. That is scope. The
Right.
purpose, the objective, that all covers in the scope of work.
Right. Right.
Yes.
So one other question we have is, how should we draft arbitration clause, and suppose if a dispute arises, how will the matter be referred to arbitration?
Because sometimes arbitration can be appointed by the company as well. Other party agrees, then if they have agreed, no harm into it. Sometimes if there's a you need an expertise or all that, arbitration appointed by either party, then they appoint a third arbitrator. Arbitration cannot be in even number. It should be in odd numbers only. It will be 1, 3, 5, 7. Generally, it happens. So if the parties agreeing that they are agreeing to the arbiter appointed by me, it's okay. If they objection, so if one arbiter can be appointed by the either parties, they both can appoint the third arbitrator. That also works. And arbitration, the jurisdiction is a most important part in arbitration. Where you want a seat of arbitration. Okay, so once you have fixed the seat of arbitration, all that jurisdiction of those location only have the jurisdiction to entertain any section 9, 7, 34 or all that. So that is the one part. Any other question on this?
Right, right. So in arbitration, I have seen that there are confusions when the parties who have agreed to arbitrate in the contract, but at the time of this dispute, they have trust issues, and then one party does not wants to go to arbitration and other wants to. So how does this?
Once you have signed the agreement, and there is no record of any separate arbitration agreement. Once you have signed the agreement, it contains the arbitration agreement. And at the first instance, you are invoking arbitration. The other party can't. They have no right to oppose it, because you have signed the law is very much clear on that. Once you have signed the agreement, you can't go beyond that. Even there is a remedy section 548 says, suppose there is a contract between me and Akshay with you. Okay, there is arbitration agreement. You approach to a civil court. I will come to the civil court. You have no jurisdiction because there is arbitration agreement. Our matter shall be referred to the arbitrator only. Then we'll move to the high court for appointment. If there is no arbitrator, suppose, then we move to high court or to consult high court for the appointment of arbitrator. But there should be arbitration clause. If their name of arbitrator clear, we will, suppose he says, I'm not in a position to carry out the arbitration, any party can move to high court for the appointment of arbitrator. So it's totally as per the agreement.
Right. Right.
Yeah. Next. I was just reading. Can some challenge? Some question was there. Okay, let me go to the question one by one. Can one challenge the appointment of arbitrator, sole arbiter by client is always one-sided? In the beginning, that is what I told you. When you are signing any agreement or you are advising your client for the agreement, you have to go through each and every clause very carefully. Once you have signed to agreement. You can't go back to that. Because there are so many judgments which says the courts has no right to interfere in the agreement with the parties if there is a valid agreement. If there is no they are within the scope. If there is no any illegality involved. If something against public policy, something against the public, then only the courts can interfere. Otherwise, the courts can't interfere. What if the parties have settled their dispute by arbiter, but due to some reason the arbiter is not available, nothing regarding this is mentioned in the contract? How is the dispute? Best move to the high court for the appointment of arbitrator. Every high court now has a body of the arbitrators. If you have your arbitration is not able to do, then you can approach the high court for the appointment of arbitrator under section 11 of Arbitration and Conciliation Act 11.6.
All right, so there is one question, I'll rephrase it also. So the question is, I want to know points clauses to be considered in commercial contract. So I guess we did discuss the various clauses.
Yeah, promotion first, scope of the promotion. So I'm just giving, suppose company A appoints company B to promote his products, brands anywhere, all that. First, you should be very clear, B will be only it's a one-to-one agreement. It's a between, the B will not act as agent of A. Why it's important? Because once you are appointing somebody agent, any mischievous, any wrong done by B, then the A could be liable. So you have to ensure that any activity is independent. You are assigning this scope of work for promotion only. He would use your logos, your property in a particular manner, not for any other use. He should not start his own business by using your name. He should not get into the business. That is a more thing, promotional. Somebody told me IPR thing. IPR is a very wide scope. Now tell me what kind of IPR you want to discuss. It's a music, it's a copyright, it's a film, it's a trademark. So what kind of IPR you want to discuss?
Sir, I think we can talk about trademark because it's very widely used.
Yeah, trademark, obviously.
Yeah.
Trademark, IPR, you have to make very much clear in your contract that somebody will not use your IPR. Your IPR material is exclusive your. I'll just give you an example. Suppose you assign a firm to promote your work or all that. And that is a wrong example. Suppose you are assigned, you make a, have an appointment company to promote your business or all that. That he cannot use your trademark for your own work. They cannot use anything, any of your material, your trademark, your any other your logos for your own promotion or all that. So your promotion, your trademarks, your work should be used only to promote your business only. What kind of question you need in the trademark? Tell me. Because trademark and copyright both are totally vast difference. Copyrights is generally where there is an artistic work like film, music, any book or all that. That is a copyright. Trademark is done by all the companies. So both are a kind of a different, I should say, both have a different terminology and different kind of treatment required. Ask me any strange question on the trademark or the copyright. Because
all right. So one of very widely used contracts in this regard can be franchising agreement, because we see a lot of registered dealership.
Yes,
right,
yes,
right.
yes.
So
yes.
how does it works in that?
I just so franchisee is basically franchisee. You are franchisee. You are giving some a license to use your name to carry your business on your behalf. You will charge some franchise amount as a consideration. That is okay. That is the scope of your agreement. That you will use our name, will provide study material, will provide everything to you, will provide this, will provide this, then we'll charge this much money to this. In a franchisee, the NDA becomes a very much important in a franchisee agreement, because the franchisee should not make any disclosure without permission of the main party. That is very important in a franchisee agreement, because both are getting business. The person is using your name, everything. So he's giving it some 20-25% commission to you. That's okay. But he should not misuse again. So that contract should be very much clear. That again, this is a scope of work. How much power you are giving to him. How much scope you are giving to use your this material or your product or all that. Something called non-competition. Non-competition is a one thing I mentioned about my lecture as well. Non-competition is very much clear. You can say to somebody that as soon as you are working with us, suppose I enjoy some monopoly in one particular product. Okay, so to secure my interest, I would not like he should make some similar product for the other companies as well. So I have to we have to make very much clear in the agreement that he will not solicit any other client for same or similar product, because it could affect my monopoly into the market.
Right.
Some Kshitij Raju has a, sir, will you please explain what competent means regarding the requirement that agreement be between the competent party? So what do you mean by, you have to very much, there is no clarity in your questions. Just come with the clear questions so that I can give you clear answers or all that. Yeah, any example for indemnity? Indemnity, it is a very wide scope. I just tell you, suppose I am appointing somebody to carry out certain works or all that. Okay, our agreement for what, 3 years. Okay, something happens or that person fails to perform his obligation or duty. then the indemnity works. Any loss suffered by me due to that he need to indemnify me. Indemnify means suppose I am suffer any loss, the other party shall indemnify me, my company or all that. That is indemnification. He was supposed to do certain work. He failed to do certain to that. Due to that, I suffered a loss. Suppose I just give an example. I took a contract from A. Okay, I subassigned to C. I'm a B company. Okay, and within a time period of 1 month or 3 months, I was supposed to give that. Okay, but the C made a delay. Due to this, I lost my future contract or all that. So I suffered a loss. So I will make ensure that there is an indemnity clause that in case of any loss or damage suffered by me, the C shall be liable to pay me, or she shall be indemnify me. That is indemnity means something happened, then only you can claim. One more thing today, force majeure. I also missed to discuss with you force majeure, because force majeure is what? Anything which is beyond your control. That is force majeure. During this lockdown, also you must have heard force majeure are widely used by many companies. But there was one very good judgment by Delhi High Court by Justice 𝗘𝗳𝗂𝗃𝗃 Singh. You cannot claim force majeure if you haven't mentioned about the force majeure. Suppose there is a reference of force majeure. Force majeure that something happens beyond human control. Suppose any act of God, any flood, any disaster or all that. So this corona is also a disaster or all that. So the court was very clear. If there is a force majeure clause, then only the other party can avail. So many people came and our rent should be waived because of force majeure. We considered it, yes. Sometimes 30%, sometimes 50%, but that clause should have been there. There is a very famous case in the Ms. 𝗘𝗃𝗃 Singh given a judgment. If there is no force majeure clause, you cannot come and say because of this happened, so I should be there should be waiver of rent or all that. So force majeure also plays an important role. That should also be there. Anything which hasn't happened beyond human control.
Sir, I have 2 follow-up questions. So when we are drafting force majeure, so I have seen people draft it like this: any act of sovereign. So does this act of sovereign, is this like a blanket clause that can cover lockdown, etc.?
No.
Or you have to be very specific?
No. You have to be very act of sovereign. Sovereign is what?
The state government.
State government will not do anything which is affecting your business. If you're doing some illegal activity, obviously government has power to curb it. So act of sovereign, you have to very much clear any act which is beyond my control, or things are beyond human control, any disaster or all that. So that in that case, obviously you can avail this force majeure kind of a benefit or all that.
Right, sir. Right. So also, yeah.
Just answer Mr. Anandra. There is a question: can court get into reasonable fairness of any contract clause? Generally, no. Unless something is against the public policy, the court doesn't interfere. That very famous judgment that court has no right to rewrite the agreement between the parties. If there is any clause which is against the public policy or against the state, then the court has right. The court's interference is very much limited. That's why when the arbitration goes, people move to the high court or any court. Court say no, we can't interfere. If it is something against public policy, obviously the court has all power to review the contract. Otherwise, courts doesn't interfere.
All right. So one other question with regards to indemnity, I had that people usually confuse. There is a confusion between indemnity and damages. So how do we differentiate that?
Indemnity is something. Indemnity is if some act has been done. The indemnify. Suppose I have been to pay. I have to pay certain things. Then obviously I will claim that from third party or from you, if there is any loss caused to me. Damage, if there is a profit due to non-performance of the contract. There is a much difference between the indemnity and the damage.
Right.
Indemnity, something has been done because of your non-performance, or then you will indemnify me to that amount only. How much the loss I suffered only.
Right.
That is indemnity.
So damages come into picture when I'm not performing the contractual obligation.
Non-performance, yes.
Yes, and indemnity when I'm doing something else which causes injury to you.
Yes, which injured you basically, na.
Mm-hmm.
Whatever the loss I suffered, I will claim indemnity from you. Otherwise,
Right.
indemnity is very limited. So damage is very vast. Damage, you perform, but you given a inferior quality. I can claim for damage, and indemnity will not come into picture. Indemnity, you have to show that I suffered this loss, and that's why you have to indemnify me. That's why the damage has a very vast scope basically.
Right.
But damage cannot be in a very you should be very much reasonable while calculating the damage as well.
Right.
Suppose I just give you example. Suppose there is a lease and license agreement. Okay, there is a clause of a lock-in period or all that, 12 months, 18 months or all that. So if suppose somebody is vacant the position 12 months, he can only claim the rent for the 6 months. He cannot go the market value increase, so I would get from 18,000 I will get 30,000. No. What is the damage? If in the normal course, the court will give damage only that only.
Right.
Yeah. Yeah. What if government changes law and it lead to indemnity? Who will be responsible? When the government changes law, will be tied like the Akshay is a sovereign. Here comes the sovereign state. If a law change, something done because of my negligence or my incompetency, then obviously I will indemnify. But the government changes law, something beyond my scope, obviously you cannot claim anything from me. I have no responsibility to, because we both suppose I appoint someone to career to for production of this. Okay, the government after a certain time government bans that production, that you can't do that. Obviously, I cannot come here because that is beyond his control. Now there comes a force majeure, which is beyond him beyond the control of the human or my control. That is the force majeure part. Yeah, next.
So I have my own questions because I don't see any questions from participants now. So I wanted to ask, so when two people or two companies are getting into a business arrangement, let's say they are making a joint development, joint venture for some business. So,
Sorry.
uh, yeah.
Yeah.
So the commercials of business, key, this person is going to do this and this person is going to do that. Where do we cover that? Is it in representations and warranties, or where do we cover the commercials?
That is the scope of work.
This
Commercial. So all commercial terms will be scope of work. For what purpose I am appointing you? The objective and the consideration. A is giving any job to you. B, so A will assign work. B is interested in the consideration money part. So that is all the scope of work. The representative warranty is that what should be done in incidental that.
Right.
Suppose representation is best part. Suppose I am changing my office address from one state to another. It's my duty to inform you.
Right.
There is any change in the management of my company. Okay. Also, question of covenants come. I have to ensure. Suppose a bank guarantee is there. I have to ensure I am keeping this balance. I will not encash this guarantee without your consent or all that. So all this scope of work is very much clear. All this additional part will come that. Any commercial activity which you are talking of, that should be only in the scope of work.
Right, sir. Okay, understood. All right, so we did talk about non-disclosure agreement before, so that reminded me of one experience I had. So nowadays clients approach you, they are very specific about what they want. Maybe they learn it from Google or something. So a client approached and he wanted a non-disclosure agreement. Then when I made it, later I realized they did not have a software development agreement. So I should have consulted them to have that. So how do you start when a client approaches?
Disclosure. Non-disclosure is what? When something is disclosed. If there is no disclosure, what is non-disclosure? Nothing is there, na? You should have, like suppose you made any software development. You appoint somebody to prepare to develop a software for particular software for me. Okay, you will assign, you will ensure that any matter related to that software, anything shall not be disclosed to the third person without my consent. Without either to my employees or to the my knowns. Suppose obviously B company must have certain employees, so they have a duty that they will take a disclosure agreement from the their employees as well. They shall not disclose anything related to this to the outside world without our consent or all that. Then be important duty become very much important. Because
Right.
unless you disclose, non-disclosure cannot come into picture. Because
Right.
today in this technology world, because any software is its own relevance. After some time, 2-3 months or all that, if you make a software, you invested 3 years to develop a software. Somebody use that and make a duplicate of that. Obviously, you lost a big business. So disclosure and non-disclosure plays a very important part in that.
Right.
When you are appointing any company, you have to ensure that any of his employees, agents, or all that, they will not disclose anything beyond that. So it is obviously you cannot go to every employee of the B. So B company has to take in this non-disclosure. Acha, in non-disclosure also you should put an indemnity clause in a non-disclosure agreement.
Mhm.
Because if you suffer any loss because of your disclosure, obviously you have to you can that B should indemnify A, na?
Right. Right. So my question was also in this direction that clients approach when they approach, they have very specific demands that I want this agreement and that. So how do we start? Where does our consultation starts? Do we just, you know,
You go first try to understand what the scope of business.
right,
Scope of business you are manufacturing or service. It has two things. In a service, in a manufacturing, the product become very much important. So you have to ensure that product it should not like he should be involved be engaged with other parties for the same kind of product, or mine should be what should be priority or all that. If you have monopoly or all that, you won't like that they should duplicate it, and that your design or all that shouldn't go outside premises of anyone to any third party. In a service agreement, the IPR plays a major role. Your trademarks, your copyrights, your technology. Suppose in a music industry, in a film, what is important? Script is important.
right,
Okay, so you have to ensure all these are should be within that shouldn't be go to the third party without your consent or all that.
right,
Yeah. So first you have to understand scope. What kind of scope over they have come to you. Scope over you decide, then you will decide with the other things. Scope
mhm,
over decide, then warranties. What the warranties or all that comes in picture. What is required to like there is a company law na. One is the main
mhm,
object, one is the ancillary objects.
mhm,
So main object is what? Main object is your scope of work. Rest all is the
right,
ancillary. How you will do to carry out that work. That is your ancillary. That is then your representative warranties or all that. Then arbitration will come into picture. Then IPR will come into picture. Then indemnity come into picture. Then force majeure will come into picture. And if say lease license, obviously then there's a this what you can say this lock-in period or all that.
right,
In service agreement, point out the arbitrary differentiate main object and main object. I just give example like in a companies act, there are main object. Main object is scope of work. All representative warranties and convenience are part of the ancillary object. How that the way you can differentiate these.
right. So we have to be clear with scope of business before
Yes,
drafting actual agreement.
actually yes. And once again one thing I'm repeating here: the person who is signing agreement, he should be competent enough to sign the agreement. That you have to ensure.
Right,
Sometimes company backtrack. We never authorized this person. He did it in individual capacity. We're taking action against him. No, but I will support. No? To the person
mhm,
who is signing, he should be well authorized to enter into a contract. So that's why it's become very much necessary. This name should be come in the through this person. The capacity is designation, and he should sign when the agreement as well. This person has signed his entire name, detail, or all that. So you have you have to check the document as well, under what capacity, whether he is authorized or not. Because if he's not authorized, then you have to again the litigations or all that. Now company will say we never authorize him,
mhm,
so they will try. Obviously, it will take time, but obviously then you have to suffer for the next time, not over some time. You have to
mhm,
incur the cost to for your contract or all that.
right.
I think people have no questions, so we can close it. Actually,
Yes, 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 sir.
okay.
Uh, Thank you so much, sir.
You people can connect me at LinkedIn as well. Mine is Gulshan Sachdev. So I will share my link as well with you so that you can pass it to others. Any queries you can send to me. Okay. Thanks a lot.
All right.
Thanks. Okay,
thank you
bye,
so much, sir,
everybody.
for taking
Bye.
out your time. Yeah.
Thanks a
Looking
lot.
forward to do more webinars with you. Thank you,
Sure,
sir.
sure.
Thank you.